Good. Hope you're fine. Welcome to Lawyers Infohub Academy. Yeah, it's an academy because we are trying and we are trying and we are trying to build lawyers. We are building capacity in terms of knowledge. We are supporting the growth of the legal profession. So in today's class, I'm going to talk about understanding the principles of data processing. Many lawyers are tech savvy, while some are not, but they don't really understand the laws, the legislation, that is in the area of technology in terms of data protection, data processing, and all of that. So today we're going to just run on the principles of data processing. So if you're ready, I'm also ready. So sit back, relax, and just listen. I know you learn something. I know knowledge is something that when it comes and you appreciate it, it impacts you, and you can be able to use it for yourself and for others, positively. You must understand, Nigeria is now a country that is one of the great users of technology, in Africa, and we are even exposed to several forms of technology, ranging from the telecommunication, issue of social media, and all of that. But many people do not even know if there are laws in this area because a lot of people see it as something novel. A lot of people see it as something very novel. So a lot of people see it as something very novel, and they are sometimes confused as to if there are issues around it, how to go about it. So I just hope this lecture will help you. So we must understand that in 2019, precisely 25th of January 2019, um, there was a legislation that was, brought to the limelight. I'll use that word, brought to the limelight. It gained prominence in Nigeria, and it was issued by the Nigerian Data Protection Regulation. We have a body known as the Nigerian you know, Data Protection Agency. They are into regulation of anything data in Nigeria. It also work together with the technology department and the technology sector. Now the NCC too has, they all are all stakeholders in this data protection issues. So all of them have the role they play. So a regulation was put out by the Nigerian Protection, no, by the Nigerian Information Technology Development Agency. The Nigerian Information Technology Development Agency is one of the key institute or key organizations that it is being set up or have been set up in Nigeria to see to issues of technology data, and there are also key establishments that have one or two things to do with technology and data issues, so they all work together. But this regulation, the Nigerian Data Protection Regulation, was issued by the Nigerian Information Technology Development Agency. It's called the NITDA. NIT, NITDA is the agency, while the NDPR is the regulation. The NDPR means the Nigerian Data Protection Regulation. So on 25th of January 2019, this regulation was issued to help us, regulate the data space, to regulate data processing in Nigeria, data collection, and all that. So that regulation represents like a bedrock of data protection, you know, statute or legislation. It's like the bedrock, and other activities in that field, because it's a broad field. So that is the regulation that is in force for now, and the inspiration of that regulation was drawn from the European Union General Data Protection Regulation. The European Union General Data Protection Regulation. So that's where the inspiration for the Nigerian Data Protection Regulation was drawn. So I just needed to bring these issues. This is like the introduction to our class topic for today. So you must understand what NITDA means. That's the Nigerian Information Technology Development Agency. We also have the NDPR, that's the Nigerian Data Protection Regulation, which is a regulation that came to force on the 25th of January 2019 to regulate issues of data processing, data collection, and all of that. I also mentioned that the Nigerian Information Technology Development Agency also work together with other agencies that have things to do with technology, data, and all of that. So they don't work alone, they work with other agencies too who have something to do with data. So now let's look at the main topic of today's class, which is the principles of data processing. Now, I mentioned the European Union General Data Protection Regulation, which is where we drew inspiration for our own regulation. So many things in our own regulation has a semblance of what is in that GDPR. So one of the first principles of data processing is what is called lawfulness, fairness, and transparency. 3 in 1. Lawfulness, fairness, and transparency is very key. Very, 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 very important. So these three it's 3 in 1 because it's the first principle, but it's 3 in 1. It's a triple, or a principle that has 3 folds: lawfulness, fairness, and transparency. This involves that when data are being processed, the goal must be lawful. What you are going to use that data for should be lawful. It must accord with the principle, the reason for the purpose for which it is meant for. Anytime data are being collected for illegitimate purposes, then it's unlawful. So you must understand that the principle is of the view, or the principle postulate processing must, or anything and data processing collection must be lawful. When you're putting data together for an unlawful use, then it offends the principles of data processing. It must be done anytime data collection or processing has to be done. It has to be done in accordance with dictates of the status, the regulation in place. So whenever it breaches these statutory provisions or the regulation, there'll always be a penalty for that. In terms of lawfulness, the controllers of this, data processing or data collection, those in charge, they cannot do anything with the personal data that is unlawful. So they must always follow the purpose for which it was created. If you're collecting data for A, or for purpose A, you should be able to use it for that purpose A. Once you derail from the purpose for which that data was collected to now do something else, you have breached this principle, and you can be made to be liable for it. It's also important that if you're processing data to commit an offense, it is obviously unlawful. So if for example you have a matter as a lawyer, issue of data processing, or issue of data was collected for something and it was used for another thing, or you have something related to this, in a case your handle is related to issues of data processing or data collection, you have to look at this principle to know whether, in terms of your clients, have they breached it, or the other party involved, have they breached this principle of data processing. So when you collect data and you use it for another thing that is not meant for, it is a breach and it's a violation. In terms of transparency, any information or communication that concerns the processing of personal data must be easily accessible and easy to understand. If you're going to collect data, if you're going to understand the stages, it has to be simple, it has to be easy to understand, so that people who are releasing their information should be able to know why they're releasing their information. Plain languages must be used in terms of passing the information or stating the steps to be followed. It must be in plain languages. There must not be anything hidden. People must know what you're doing with their information, in whatever respect. People must, so whatever language you're going to use, it has to be transparent, so that people must be able to understand clearly, so that there will not be any hidden agenda, behind what's the reason for the data collection or data processing. So if transparency also is lacking to also fairness, it means the people that are collecting the data must be honest, they must be truthful, they must be open. Just like I earlier said, people must be, the information you need must be passed in a language the people understand. So you must let the people know exactly what you're using the data for, and they must be able to understand it, the reason, before they should release their data. It's also important to know that a person whose data or a person who is releasing his data has the right to know why he's releasing his data. If, for example, now very soon we'll go for census, or as a do election and all of that, okay, you need to come and register, bring your details. These people should be able to get responses from these people in charge to know exactly why are you collecting this, of what use is it, why should I do. So the whys must be answered. So a person who is releasing his data has that right to know the reason why you are collecting the data, collecting it. Now, the second principle of data processing is what is called purpose limitation. Now, the data must be processed. That is, to be processed, it has to be processed for a specified or legitimate purpose. Just like I also stated in the first principle, what is the purpose? If you are going to collect data in a community, the community must know, why are you collecting our data? Why do you want to know how many we are? Why do you want to know the personal details of people in the community? Why do you want to know this? Why do you want to know that? So the data must be processed, collected for a specified or legitimate purpose. It should not be for an illegitimate purpose or unlawful purpose. Now, if the purpose for collecting that data, processing data, is for A, just like I earlier mentioned, once you deviate from that, it becomes a breach, and the person can be made to be liable for that. Because if the purpose is for census, for example, I'm using for this for example, or if the purpose is for the election or something, then let it be for that. You're not supposed to use people's data, deviate from what it is meant for, and use it for another thing. Yeah. Another thing is data minimization. It requires that the personal data must be adequate, relevant, and limited to what is necessary in relation to the purpose for which they are processed. This is also intertwined with the earlier principle of purpose limitation. Data minimization. The personal data must be adequate, it must be relevant, and it must be limited to what is necessary in relation to the purpose for which they are being processed. Data collected must not be disproportionate or excessive with respect to the purpose of its processing. Yeah. So it has to be adequate, it has to be relevant, and limited to what is necessary with relation to its purpose. Now, so only relevant and necessary and adequate data required to accomplish the disclosed purpose must be collected and processed. If, for example, what you need those data, for example, you just want to know if this person is the male, okay, for example, in a community, you're supposed to collect data for just to know maybe the child mortality, for example. Just want to know, okay, like how many women are pregnant, or in the last 2 years, how many women have been pregnant, how did they have a stillbirth, and all of that, just to get the rate or the statistics on child mortality, and you leave that stat and start looking for their BVN, start looking for their financial records, and start just say put everything. No, 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 no. It should be limited to the purpose for which you need it for, not anything extraordinary. If you need the child mortality, should just based on knowing how many women have been pregnant. If your period, the period you're looking at is 5 years, in the last 5 years, how many children have been born, how many have lost their children. So it should not go beyond that. This shows that there are a lot of violation out there. People collect data, so it's a lot of people will start receive messages, wondering, who did I give my number, or how did these people get my number? So these are breaches of data processing. These are breaches of principles of data processing. If you release your data for just maybe for a telecommunication company, or people have now access to it. I'm using this for example. This is just an example. People now have access to it to now maybe do other things. Then there is a breach. So as a lawyer, you need to understand it. So where you have cases linked to these areas, you'll be able to understand what principle did they offend. Is it the principle of purpose limitation? Is it the principle of data minimization? Is it the principle of lawfulness, transparency, that we earlier talked about? Now, under the principle of data minimization, we have the concept of necessity and proportionality. The controllers of this data must be bound to consider whether data collected are necessary to achieve the goal on one hand, and as well as the size needed for that purpose. So looking at under data minimization, the twin concepts of necessity and proportionality. So the data controller must be able to consider these data I'm collecting, are they necessary to achieve the goal, the purpose on one hand, and the size of the data needed for that purpose. So the size and the necessity. And is it necessary for me to collect all this? I just need to know whether these people are female or male. I need to just know maybe how many females are in a particular community. This, for example, you now start looking at beyond knowing whether there are how many females or how many males. You're now asking for extraneous things which will affect the size of the data. So these are the twin concepts under data minimization. What you're asking for, is it the data you need? Is it necessary to achieve the goal, as well as the size of the data needed for that purpose? So this twin concept of proportionality and necessity is important under the principle of data minimization. So the fourth principle is the principle of accuracy. Personal data should be accurate and, when necessary, kept up to date. Like in the National Bureau of Statistics, they have statistics for a lot of things in Nigeria. If you want to know the number of this, the number of that, they can give you that statistic. So every time they always keep their data to date or up to date, so that if what happens, maybe the rate, maybe if there's a drop or an increase, so they're always keeping their data up to date. So there must be accuracy for data processing and data collection. So it must be kept up to date. Data will be inaccurate when they are incorrect or misleading. So a lot of people sometimes rely on this data processing, data collection. So if the statistics are wrong, it affects the output. So one of the principles is that your data must be accurate for the purpose for which you're using it for. The fifth principle of data processing is also storage limitation. Data shall be kept in a form which permits identification of data subjects for no longer that is necessary for the purpose. If the purpose for which the data is being collected is for maybe a period of 5 years, then after that 5 years, why keep it? So data processed under this rule shall not be retained or stored for longer than is necessary. So that means the time duration for whatever data you're collecting. So at the end of that duration, and you're done with the purpose for which you're collecting, you're supposed to dispose of it. So even though there are some data that are needed for a long period of time, and they are being reviewed from time to time. It's also important to know that storage of data beyond the requisite time frame is a breach of data protection law and other extant law establishing storage time limits. So principle of storage limitation is very key. You must understand what was the duration of this data, and have they exceeded the duration period? Why are they still holding on to the data? Why is it still there? So when you have issues on issue of data protection, these issues of data processing, so these are the principles you are going to look out for, to ascertain the case maybe you're handling, or you want to do an evaluation. So these are the principles you have to consider. The principle, just like from the fifth one, the storage limitation, the principle of storage limitation. The fourth one, the principle of accuracy. The third one, the principle of data minimization. The second one, the principle of purpose limitation. And the first one, which is 3-in-1 principle, which is that of transparency, lawfulness, and fairness. You'll be able to learn. If you didn't even learn anything, you'll be able to learn. It's the principles of data processing. We have these 5 principles, and over time, I know that as the years goes by and a lot of things might come up, but basically this is what we have for now. So these are the principles that govern data processing. So as a lawyer, you should be able to know it. As a law student, you're supposed to know it. And for someone who is interested in data protection law, who's interested in cyber security, who's interested in information technology, very, very well, because it's going to help you in analysis. It's going to help you in your work. So friends, I just hope you learned something today. Can I please drop your comments? Let me just hear your thoughts on this. Let me see what you think. And if you have any question, you can also drop it on the comment section. I'll revert back to you. If you've not subscribed to this channel, please do hit the subscribe button. Share this video. For those who have subscribed and who keeps coming back to know what is new on the channel, I appreciate you. I appreciate you. I do not take you for granted. The reasons why we're still doing what we are doing. Thank you for giving us that courage. Thank you for always supporting us. Thank you for making us know that this thing we are doing, we're not wasting our time. Thank you very much. And I just hope that you've learned something, you'll be able to pick something from today's class, and it will help you become a better person. Know that there's always the better version of who you are. Don't settle for less. You don't be a mediocre, and know that you can be better. And where you are is not where you will be forever. Strive to be the best version of yourself. So do take care of yourself and do stay safe. Thank you.